Honorable Prosecutor General Péter Polt, Honorable Madam Minister Judit Varga, Minister Sándor Pintér, Honorable Madam Constitutional Court Judge Agnes Cine, Honorable President György Senyei, Honorable Ambassadors, Honorable Madam Secretary of State, Honorable Permanent Secretary of State, Honorable Head of Office Professor Szilágyi, esteemed guests, dear ladies and gentlemen, dear colleagues. I respectfully welcome all of the participants to the present international conference. It gives me a great pleasure that this prestigious event is hosted by the Curia of Hungary, the oldest Supreme Court in the European continent. I would like to thank the co-organizing institution, the Ferenc Mádl Institute of Comparative Law, for its organizational work, and the Faculty of Political and Legal Sciences of the University of Miskolc for their support. Hungary's fourth criminal code, Act 100 of 2012, is celebrating its 10th anniversary. This round number anniversary provides an opportunity to review the experiences gained so far and to draw some conclusions that may be useful for the future. The importance and significance of criminal law, of codified criminal law and the criminal code in a legal system under the rule of law cannot be questioned. The existence of a criminal code is in itself one of the main guarantees of legal certainty and the maintenance of public order. Therefore, the code itself must provide stability, while the modification thereof is also inevitable if the circumstances of its creation and application change. This may be due to a variety of developments, such as societal and economic phenomena, changes in the code's interpretative framework, scientific progress, and the need to comply with international and European Union obligations. As Madam Minister Varga also highlighted, in spring 2011, our Parliament adopted the fundamental law, basic law of Hungary, which created and provided for a new constitutional framework. The requirements of the constitutionality of criminal law, developed originally in the practice of the Constitutional Court, have been extended with new elements and have been placed in a new system of interpretation, even if the wording of some relevant and important fundamental rights has remained almost unchanged. The constitutional right of legitimate defense has been introduced as a new element in Article 5, but other important changes have also been made, such as the introduction of the requirement of interpretation in Article 28 of the Fundamental Law. The new criminal code has retained the doctrinal basis of the 1978 Criminal Code and has expanded them by adding a number of principles of constitutional criminal law. One of the main expectations towards the new criminal code was to be strict. The ultimate goal of the reform was, nevertheless, to create a unified, modern, consistent, and effective criminal code. Although the new code has been modified a number of times, the Curia, the Supreme Court, is seeking to fulfill its interpretative role and to ensure the uniformity of the court's case law. Our main instrument of it is the delivery of uniformity decisions that are binding on all of the courts. The Curia has issued a number of uniformity decisions in the field of criminal law. For instance, on the distinction between homicide and other crimes against life and limb, on the uniform interpretation of the conditions for legitimate defense, on the imposition of life imprisonment, and on the classification of misappropriation of funds as a natural unit or as a continuing criminal offense. The celebratory conference provides an opportunity to review the legislative, judicial, and enforcement questions that have arisen so far and to formulate new ones. But the primary aim of all this should be to promote the stability of the criminal code. I'm glad to have all of you here and wish you fruitful discussions. Thank you very much for your kind attention.